I've asked for a handheld mic because I hate these things. Nothing, I just can't stand it. Many of you are lawyers, I think, in the room, and you will understand. I was a trial lawyer for longer than most of you in this room have been alive. I've been practicing law for almost 35 years, and I look around and I see some of you are not even 35, which is very disturbing. So as a trial lawyer, I got used to walking around, and I don't stand still with a podium. I'm an American, and when we try cases in America, it's not like it is in many other countries where the lawyers are very formal and they stand still and they speak in measured tones. When we try cases, we speak with emotion and passion, and we try to somehow persuade. We don't persuade on the law, mind you, because the law is unimportant. We try to persuade with making the judge agree. I was telling one of my children, in fact, yesterday, because I think she will make a wonderful trial lawyer, because she argues with me about everything, and the facts are never important. And what is right or wrong is never important. She just argues based on what she really thinks it should be, and it's very passionate. And I say, you would make a wonderful trial lawyer, but only in America, nowhere else. So let me say something else, too. Americans supposedly always start, I was at a conference in, I think it was in Bahrain or in Dubai, and the person before me speaking said, he was from another country, not America. And he said, you know, the difference between Americans when they give speeches and others when they give presentations is Americans always start with a joke. And so he proceeded to say, I'm going to do this as if an American, and he kind of winked at me, and then he told a joke. And no one laughed. And then it was my turn later on, and I stood up and I said, I have to tell you something. I have two problems. One, I never start with a joke. I used to. But I don't any longer because, first of all, I can never remember enough jokes to tell them. I always forget the rest of the jokes, so it's pointless. Number two, when I tell jokes, no one ever laughs. So it's silly for me to tell jokes as well. No one gets them. They're usually very bad jokes. So I won't start with a joke. But let me tell you a little bit about Islamic arbitration, which is a more serious topic. Okay. And supposedly this all works. It does work. I think I will move fairly quickly. I have 30 minutes, and there's no clock in here, so if we're in here for 3 hours, you won't know the difference, will you? But I won't know the difference either, so they promised to tell me when to be quiet. I think most of you that are in this room are here because you are interested in Islamic arbitration, which means you probably know something about Islamic finance and about what an exciting industry this is, Islamic finance. We see important growth happening. Datuk Raju mentioned it briefly. The growth, most parts of the world, we speak of Islamic growth, Islamic finance rather, growing at 20 to 40%. Those are some big numbers. I always tell my students at the university, if you want to know what area to specialize, what will be the future career when you graduate from university and you go out into the world, look for the areas that will have the greatest growth. And they get very excited about IT and high tech and biotech. These are very important areas as well. But I challenge them, find me an industry that's growing at 20% per year. Find me one. Find me an industry that in some parts of the world is growing in excess of 50%. In Indonesia, the numbers that I keep seeing from Bank Indonesia, and they change, of course, somewhat often, but the numbers that I see are almost always more than 50%. I've seen numbers as high as 57% from Bank Indonesia. Find me an industry that's growing this fast. I don't know one. Many years ago, not many, a few years ago, in the New York Times newspaper, there was an article about the best career choices for young people growing up. Number one career choice, hairdressers. I love that one. Hairdressers. And they said because everyone grows, well, not everyone. I find I'm growing less of it lately. But everyone pretty much grows hair. They need a haircut. It's a great area. Growth of hairdressing annually was around 6%. And they said, this is big growth, 6%. And I look at this, 20%. So think about that. We have an industry that currently is around 1.5 to 1.7 trillion US dollars assets under management. These numbers, again, depending on whom you ask, I think Bank Negara Malaysia has published numbers around 1.8 or 1.9 trillion US. I see in the Middle East very often 1.5 trillion US. We're not quite sure what the numbers are. Whatever they are, those are good numbers. What's more important is this industry grew 5 times in 1 decade, 5-time growth. That's massive. Now, it only represents around 1 to 3% of total financial institution balance sheets globally. That's small. And we're still seeing only about 600 Islamic financial institutions globally. Again, that's small. But think about where it's headed and look at pockets of growth in particular. If you're in this region, which you are, this is the great place to be. If you were sitting in New York City and I was talking to you about Islamic finance, it would be a very different topic because there isn't much happening in North America, even in Islamic finance. If you were in London, you would be excited because we see London suddenly expressing a tremendous interest. I'm head of Islamic finance practice for a London firm, DAC Beechcroft. When I speak to my colleagues in the firm in London, they are very excited because we see Sukuk now. We see a growth of real estate finance based on Islamic finance. We see other areas of commercial Islamic finance growth occurring as well. So this is very, very good. I've lost my clicker. Let me find it again. Look at the rest of Asia. We get excited in Malaysia because we see a large Muslim population, roughly, I think 20 million to 26 million Muslims in Malaysia. But look at Indonesia with 200 million Muslims, and look at India, Pakistan, and Bangladesh with more than 500 million Muslims. If you took only the Muslim population in Asia, and this doesn't even include Central Asia, and thought in terms of growth and what can happen for this industry, this would be in itself very impressive. There are some problems in that the majority of Muslims in these countries never go into a bank. They don't use Islamic finance. They don't use any kind of finance. But increasingly, as the industry is reaching out to the Muslim community, we see the industry growing. As it's reaching out to the non-Muslim community, which is rapidly happening in the area of Islamic capital markets and Islamic wealth management, as it's reaching out to the non-Muslim community, we see rapid growth occurring as well. So this is very important. High net worth individuals, non-Muslim high net worth individuals, pension funds, institutional investors. So I want to give you some background very quickly before we talk about dispute resolution. Because what's happened is this industry, I started getting involved with investors in the Middle East in the mid-1980s. I was practicing law. I was a partner with Patton Boggs in Washington, D.C., and we were the first American law firm to open an office in the Emirates, in the UAE, in Abu Dhabi. We started doing a lot of work in the Middle East as an American law firm. And I started working with clients in the Emirates and then increasingly also with Saudi clients who had investments in the United States. And in those days, there wasn't much interest in Islamic finance. It was just simply investment and finance in the mid-late 1980s. But what I began to see happening in the 90s and coming into 2000 and forward was a growth of Islamic banking. And from Islamic banking at sort of the grassroots level, we began to see it moving into Islamic finance, which was more project finance, large-scale finance. And from that, we saw something else that's happening, and this is very recent. And you lead the world in this in Malaysia, I think it's fair to say, and that's takaful. Because when you start doing project finance, you start having large projects, and you start doing large-scale commercial financing, you need insurance. And if you're going to do Islamic finance, then you want Islamic insurance or the equivalent to insurance. It doesn't make sense to make certain that your transactions are Sharia compliant, but then you have conventional insurance as well. So we've seen the growth of takaful. What's holding back takaful, by the way? Retakaful. The lack of capacity for retakaful. So this is actually holding takaful back slightly. But we're beginning to see the growth of retakaful as well. Minorities jurisprudence is another area that's beginning to grow, but it doesn't affect what you all do and what we will be doing in ADR. but it's also growing bad. I just mention it because what that means is, what about Muslims who are living in non-Muslim countries? What about Muslims who are living in New York City? What about what about Muslims who are living in my home state of North Carolina, U.S., where there was a new law that was passed recently that said something about not recognizing foreign laws from other jurisdictions. It's referred to as the Anti Sharia Law. If you're a Muslim living in North Carolina, how do you practice your religion effectively, and what do you do? There's this whole area of what's called Minorities Jurisprudence that's developing to address that issue. This is a very important area for law, Islamic law. And because of all this other stuff that's happening, there's something else that's happened in the last few years. And KLRCA has really led in this field, and that's this desire to resolve disputes. If you have a Islamic banking dispute, if you have an Islamic finance dispute, if you have a takaful dispute, where do you go with that dispute? This is a big question. Do you go to a secular judge? What do you do? And so we've begun to see this idea of ADR developing. The same way we saw the idea of ADR developing I started out as a construction lawyer many years ago. And the idea was that the courts didn't understand construction cases. If I went to a court and tried to litigate a construction delay claim or a construction defect claim, I had to educate the judge about construction. I had to educate the judge about scheduling and about delays and about the various aspects of the industry. Well, it was pointless. So it was much faster and better to have a specialized arbitrator that I didn't have to educate quite so much, if at all. And so we've seen this also develop, that now for Islamic finance we want to have experts as well. We don't have to educate them about what is Islam, what is Sharia, what is, as I tell my students, what is a murabaha and a mudaraba and a musharaka? One of my students raised her hand one day in class and she said, I get it, I understand it. Everything starts with mu and ends with ah. So that must be the key to Islamic finance. It's mu'ah. I said, well, it's not quite so simple, is it? I had another student who in the feedback said, I like Islamic finance, but there's too much Arabic. And I was like, well, it is Islamic after all. What can we do? Okay. So we began to see this idea of Islamic arbitration develop. What is Islamic arbitration? It's based on something which is simple, that we want to make sure that we recognize Sharia in what we're doing in resolving disputes. We've already said we want it in our contracts. We want it in our finance, in our banking, in our insurance or takaful. So we want to also make sure we recognize it in our disputes. And the key to Sharia, for purposes of ADR, is something else. It's not just what is in the Quran and what is in Al-Sunnah. It's also something else. It's what is the spirit, what is the intention, what is the purpose behind it. And that is maqasid al-Sharia. And this is very important. And we're beginning to see, I'm speaking very broad, big picture, by the way, theoretical. We're beginning to see this also become a part of ADR. We want arbitrators who not only understand what is the mu'ah, we want arbitrators who understand not only what is Al-Quran, what is Al-Sunnah, that know what is, when they see the hadith of the Prophet Muhammad, they understand what they're looking at and they understand the argument. We want more than that. Eventually, we want arbitrators who understand the maqasid al-Sharia. This is an aspiration. This is what we hope for happening. We need Islamic arbitration to support the growth of Islamic finance, Islamic banking, of takaful. We need it. We can't go to Sharia courts. In Malaysia, that's very clear. The Sharia courts have no jurisdiction to handle Islamic banking. You have a mu'amalah bench, again, mu'ah, right? You have a mu'amalah bench to handle these things. But that's not going to happen in Singapore, where I am. It's not going to happen in Charlotte, North Carolina, where I'm from. It's not going to happen even in London. So what do we have? We need something else, because the Sharia courts will not hear these cases. The secular courts don't understand it. I had a debate with a judge from, I won't mention who this judge is, but one of the prominent judges in London. I had a bit of a debate with him. in an academic setting. It was a friendly debate, not an unpleasant one. And he argued that he doesn't need to understand Sharia. This is just not important. This is really about finance. It's about banking. This is all that really matters. And I have to say that even in that discussion, there was a hostility. There was a certain, don't bother me with all this Sharia stuff. I don't need to hear about this. And we find that the secular courts not only are unfamiliar, but they're not only that, sometimes they're hostile. Sometimes they just don't want it in some jurisdictions. And so we need something that gets us around that. And ADR, Islamic arbitration, helps. Okay? We need to understand what is Sharia. Ideally, we have arbitrators who understand what is Sharia. Here in Malaysia, you refer to the SAC. This is wonderful. But you want the arbitrators themselves to understand these basic concepts and principles also. Because, as I tell my students always, these are nuanced legal concepts. It's not so simple. It's not as simple even as the common law that we're all familiar with. It's more nuanced. It's more than a set of just rules of do's and don'ts. People often think Islam is about halal, haram. It's easy. If it's not one, it's the other. Go back and forth. But it's not so simple, is it? Not nearly so simple. There are complex concepts of fiqh. There are complex fiqh rulings. So we want arbitrators who understand these things. Currently, we have Western models of ADR. I gave a presentation in Karachi, Pakistan, to the Sindh High Court Judicial Academy, and I sat in a room, or stood in a room like this, with future judges in Karachi. And as I began talking about mediation and arbitration, one of the young men in the room stood up. And he said, I always get nervous when someone starts a question or a comment to me with, I don't mean to be disrespectful, Professor. And I thought, when you start with, I don't mean to be disrespectful, you know you're about to be slapped. You know. So I said, well, then don't be. And he sort of looked at me. And he said, but we don't need your American ADR in Pakistan. There's some feelings there, some emotions, of course. And I said, I agree with you. Huh? I said, you don't need American ADR in Pakistan. What you need is Islamic concepts. And where did they come from, by the way? Not from America. Where does the basic concepts of ADR really come from? Let's go back more than 1,000 years. Before there was an America or a Canada or anybody else. Before there was George W. Bush. We don't even remember that far back, do we? When it was still a sensible country. Let's go back. There was a concept of arbitration. There was a concept of mediation. There was a concept of conciliation that existed in most of the civilized world. And by the way, what was the civilized world 1,000 years ago? Who was the civilized world 1,000 years ago? Islam was civilized. So it doesn't have to be Western-style ADR. We're still trying to do that. I advocate for moving beyond it to something better. We're still trying to do it. We want some of it because it encourages foreign direct investment. If you completely reject everything that's Western and say we don't want it, it's a little harder for MNCs to come into your country and invest and do business because they look around and they say, wait a minute, where's the stuff that's familiar to us? Where are the things that we recognize? Where's your reliable, predictable legal system that we can understand and your dispute resolution system that we can understand? We don't want, as it's sometimes referred to, we don't want qadi justice. This is used as a negative, not as a positive. I use it as a positive, and they look at me like I'm crazy. They say, we don't want qadi justice. We want real justice, whatever that means. So this is an interesting conflict that's occurring. What is this notion of Islamic dispute resolution? It starts with something which is really a tradition of sulh. What is sulh? Ooh, what is this floor? Sorry. I get distracted easily. What is sulh? It's a confused concept. I think it's a little bit confused. It is a big picture. It's a broad concept. It doesn't translate directly into Western ADR. It is a bit of mediation. It's a bit of arbitration. And when you look at the very early writing, this was the concept that existed. Sulh is this idea that we blend together mediation and arbitration in a sense, that what we're really looking for is peace and harmony. We're looking for conciliation. We're not looking just for resolving disputes and making people live with the result. It's bigger than that. It's more complex than that. This is something that we're beginning to see and argue for as truly Islamic arbitration, ultimately. I'm giving you, again, the theory, the idea of what we really want eventually. Right now, Islamic arbitration looks just like any other arbitration. It looks like construction arbitration, what I did for many, many years. It looks like labor arbitration or sports arbitration. The only thing that's different is we have some Arabic mixed in. Really? We take UNCITRAL rules and we add a few provisions that say, by the way, there's this thing called Sharia. We refer it to a Sharia council. We do, but it looks very much the same. It is the same. Sulh is something bigger and broader than that, and this is where we're headed slowly. This is some of the discussions. I'm an academic, so these are academic discussions, but I want you to be aware of it. Okay? It blends together. What is wasata? Wasata is this idea of really mediation, conciliation, and what is tahkim? It's this idea of arbitration, and it blends these concepts together, and this is what existed more than 1,000 years ago. This is probably where we're headed, somewhat. The Quran says, believers are brothers, so make peace. This is, of course, in English, not in Arabic. The believers are brothers, so make peace between your two brothers and be mindful of God so that you may be given mercy. This aspiration of peace. Aisha was quoted as saying that the Prophet said, the most hated person in the sight of Allah is the most quarrelsome person. I like that one. I know so many quarrelsome people, and I'm glad to know God hates them. Because I want God to hate them. Okay? That's terrible of me, isn't it? Said the Prophet disliked endless, especially verbose litigation. The Prophet disliked endless, verbose litigation. There's one wonderful hadith narrated about the Prophet where disputants came to the Prophet and they asked him to resolve a dispute, and he said to them, in hearing the dispute, he said to them, I am only a human being. Opponents come to me to settle their problems. Maybe someone amongst you can present his case more eloquently than the other, whereby I may consider him true and give him a verdict in his favor. So I give the right of a Muslim to another by mistake, then it is really a portion of the hellfire, and he has the option to take or give up before the day of resurrection. What is he saying? And I love this quote. I love this hadith, because what he's really saying is, you come to me with a dispute and you ask me to judge between you. I'm only a man. I'm only human. I mean, I may be the Prophet, but I'm only human. If I make a mistake and give the wrong one what I think he deserves because he's so eloquent and he speaks well and he has a good lawyer, what I'm really giving him is hell. I'm not giving him fair justice. I'm not giving him what he really deserves, and he shouldn't take it. You should never take what you don't deserve because of someone else's mistake. That's clear. I love that. So the concept of sulh, the real root of Islamic dispute resolution, what is it? It's more than just, I will decide the case and tell you. Because even the Prophet himself didn't want to do that. Didn't want to do that. What he really involves is, I will work with you, I will help you, I will try to make you find a resolution of this case. This is a radical idea. It favors conciliation. It favors settlement and agreement. We'll talk in a second about how we write this into our programs. But it is a unique procedural approach. We always think that Islamic arbitration, the essence of Islamic arbitration is substance. It's Islamic. Ideally, in the future, we will see Islamic arbitration become more than mere substance, more than subject matter specialization. It will become procedural specialization as well. This is what I hope for, and this is what we are seeing the discussions occur in parts of the world slowly. The idea that an arbitrator is more than just a decision maker, but he becomes, or she becomes, a conciliatory intermediary, a person who tries to make the parties reach a settlement as well, a person who evaluates the outcome in the case, a person who listens and presses the parties to settle where possible. This is radical. This is something new. In the Western model, and America has led the world in ADR. America led the world in arbitration in the 1950s, 1960s. I think it's fair to say. The model that was put forth was an adversarial model. It was a fighting model. It was the American way. It's how we like our courts to be, too. We like to sue everybody over everything and fight about it in court, and the judge makes a decision and somebody's not happy, but that's okay because you can appeal it. And this was the model we put forth, adversarial. And the movement is away from adversarial and more toward conciliatory. And we've seen this happen, you know this, we've seen this happen in ADR globally already, even in the West. We started to see these ideas of Arb-Med and Med-Arb. Why? Because we know that when you fight and get a decision, somebody won't be happy. And if we want people to be happy, we should try to make them settle. And Islam is about peace, isn't it? Ultimately. That is, I mean, look at the word, Islam. What's the root of that word? It's about peace. Peace through entering into servitude, submission to God. So we want peace. That's what Islamic arbitration should be about ultimately. Should it be Arb-Med or Med-Arb? This is an interesting question. Should it be mediation? Should we write clauses that have an escalation? So we have the usual clause that we see in arbitration often that says, or dispute resolution clause is the escalation clause. The parties will sit down and endeavor to resolve this dispute, et cetera, et cetera. Unable to do so, they will then submit it for arbitration to KLRCA or AAA or ICC, whoever it is, and that decision shall be binding, et cetera, et cetera. Is that what we want, an escalation clause? Do we want a Med-Arb clause? The parties will attempt to mediate this dispute. They'll work with this institution, the mediator. Unable to mediate, then there will be a decision made. Do we want Arb-Med? I always enjoy that one. You're familiar with Arb-Med. The arbitrator hears the case, makes a decision. I do this with my children. It works somewhat. I hear the case when they're fighting about something. I hear the case. I make a decision. I look at them and I say, okay, I've heard enough. Please stop. I know what I'm going to do. And they go, okay, finally. Each one of them convinced that I'm going to do what they want, of course. And I say, but before I tell you what I'm going to do, work it out. Because one of you is not going to like the answer. So go work it out. This is Arb-Med, isn't it? It's, I've heard your case. You've presented it. This is useful. Saying it out loud, getting it out is very useful. But I'm not ready to tell you my decision. You may not like my decision. Isn't this really what the Prophet Muhammad did? I can't claim credit for this. This is what he did. Now, you go figure out what you want to do. And if you can't figure it out, come back to me, and then I'll tell you my decision. This is Arb-Med, isn't it? And hopefully the parties will settle and reconcile their case, but they don't always do it. Okay. This is the theory and the concept. Now move on to the practicality of things. What do we actually want to do? Let's say we put together a contract that has a dispute resolution clause in it. We can use an escalation clause. That's wonderful. We can use Arb-Med. We can use Med-Arb. That's wonderful. But there are certain things we also want to make sure we don't miss out on because of what the courts are also saying. You heard, and I don't want to overlap with the previous speaker. But you heard the previous speaker talk about the New York Convention. You heard Dr. Raju talk about the New York Convention, enforceability. All this is wonderful, but if it's not enforceable, what's the point? If the courts aren't going to honor it, what's the point? So we have to be very careful how we draft these clauses even. We want to make sure there's specificity. We want to make sure the qualifications of the arbitrators are clear, of the intermediary. We want to make sure that there's clear choice of law provisions. So these are always problems too. There are three threshold issues to be addressed in drafting arbitration clauses for Islamic arbitration. Number one are the qualifications of the intermediary. Do I want my intermediary to be Muslim or not? I should put that in there, really, because this could reach an issue later on of Sharia enforceability. This could reach an issue if I seek to enforce this in a particular jurisdiction where the particular madhab or school of law followed doesn't recognize women as adjudicators, or doesn't recognize non-Muslims. There's plenty of authority that says that God will not give authority to non-believers over believers. Do I have a problem with that? Do I want to make sure that my arbitrator is always going to be a Muslim for that reason? I want to set that forth in my arbitration clause, because what if I don't put that in there and I end up in a fight then between, is it a Muslim or non-Muslim? You don't want that. You always want to be specific. I want specificity. Okay? As to gender, as to religion in particular. Secondly, choice of Sharia as law. This is a little bit tricky. There's a thing called the Rome Convention that talks about private international law, as you all call it here. We call it conflict of laws in the United States. But there's this thing called the Rome Convention that says that what law do I recognize as governing law, and is it enforceable? If I say Sharia, as we saw in the Beximco case, as we saw, and I won't go through the English cases, but we saw in some English cases, in particular the UK cases, and I say the glorious Sharia shall be the governing law. How wonderful that sounds. How does it sound to a secular judge, a high court judge in the UK? How does that sound to a United States District Court judge in New York City? How does that sound? That judge is going to say, and the New York Convention gives him some authority, and case law gives him some authority. He's going to say, I don't even know what that is. This is God's law? Give me the law of a state. Give me the law of France or Germany, or the law of England, or the law of New York. Or give me something specific that man-made law. The law of a state. So this is an issue to consider, at least. There is a preference for state law, not religious law. And thirdly, another threshold issue to look at is something that, I'm sorry for using Arabic, but it's the only word that works for it, really, is gharar, this idea of uncertainty. And we need to anticipate this. I won't go into this in too much detail, but I want to mention it very quickly. This is a tough one. The idea of a gharar defense. Islamic law says that everything that I put in my contract in a commercial transaction needs to be certain. I can't leave contingencies. I can't leave too much uncertainty in there. So what if I write an arbitration provision that says that if there is a dispute at some point in the future, we will resolve this by arbitration? Guess what? There's uncertainty. If there's a dispute, maybe there won't be a dispute. Have I created gharar in my contract with that very simple wording? So we look for ways around that. I'm not going to tell you about it, but I've got in a book publication, I've got a suggested arbitration clause. We look for ways around that. What's the best way around that, by the way, is when the parties agree to arbitrate, when it's time to arbitrate, they agree again to arbitrate. They say, okay, we have a dispute, we're going to arbitrate it. We confirm, we affirm, we restate our desire to arbitrate this dispute. Why is that important? Because now you can't say that because of gharar, we don't really want to arbitrate, we didn't agree to arbitrate. Because you know what happens? Everybody wants to arbitrate until they get the result. And then all of a sudden they say, oh, I didn't really want to arbitrate that. The gharar, you can't make me arbitrate that. The result is really not binding on me. I lost, right? So the result's not binding on me because of gharar. So what do I do to get around it? We walk into the arbitration. The first thing we do is we say, let's agree that we are here to arbitrate, that this is definitely the party's intention. Let's move forward. with it. So that happens sometimes. There are other conditions that we worry about, like moral probity. Arbitrators in an Islamic context have to have good moral character. Well, this is a great thing. So you want upstanding, good, moral people. I'm going very quickly through a few things. We have run into some problems with anti-discrimination laws, the question whether I can have an arbitration clause where the parties are employing an arbitrator and saying it has to be a man or it has to be a Muslim. This came up in the UK, and fortunately it was resolved in favor of an arbitrator is not really an employee of the parties. He's an independent contractor, so you can do this. But there was actually a challenge made that said that you can't make me hire only a man. You can't make me hire only a Muslim. That violates labor laws. So we always try to think about that as well going forward. Is that going to be a problem? Okay. One last thing, and then I have to stop apparently too. One last thing I want to mention is it's very good, very important, I think, in an arbitration provision in a contract from a drafting perspective. There are two things that I like to see. One is not only a reference to the glorious Sharia, and very often what you see, and it's good, is this contract shall be governed by, or the arbitration of this dispute shall be governed by the law of London, New York, whatever it might be, and Sharia to the extent not inconsistent therewith. There are different ways of drafting this. But something else that's very useful, because the courts are unclear themselves as to what Sharia means. Sharia to, and you know this, Sharia to a Malaysian is a little bit different than Sharia to a Saudi. It's a little bit different than Sharia to a Pakistani. I mean, this is my own experience. As a professor in the United States once said, we should use plural, Sharias. He's overstating it, of course. He says there are 5 Sharias. Whose Sharia are we even talking about? So it's very useful to perhaps reference not only Sharia, but reference fiqh. Which madhab are we talking about? Are we talking about Shafi'i fiqh? Are we talking about Hanbali fiqh? Are we talking about Maliki fiqh? Are we talking about Hanafi fiqh? Whose fiqh are we talking about? The Islamic jurisprudential principles that apply, the interpretation of Sharia. So this is important. In this region, you would want to say Shafi'i fiqh. But a Saudi may not like that as much. Different madhab. We think about that. It's useful to reference in an arbitration clause other external sources of authority, or I guess authority is a good word to use. For example, AOFI, such as any IFSB or other international standard-setting bodies that have rulings on various principles, such as Bank Negara Malaysia, such as SAC, such as whoever it might be. Put that in the arbitration clause. It avoids problems later. I'm a big fan of putting as much. I write long arbitration clauses. I'm a big fan of long arbitration clauses because the more you put, the less problems you have later. I hate the ones that say, we will arbitrate all disputes arising out of, and it ends there. It's useless to me. The last thing to mention, it's very useful in an arbitration clause where you're seeking to do Islamic arbitration later. The arbitrator, give the arbitrator express authority to act with the power of an amiable compositor. You know this concept if you're an arbitrator. Amiable compositor. Make interpretations ad equi ad bono. You know these concepts. What are we talking about? Give the arbitrator some wiggle room, as we would say in America. Give the arbitrator some room to avoid being locked into the law, whatever the law might be, but recognize that he can make decisions or she can make decisions based on something broader. Principles of natural justice, principles of fairness. What are we really talking about, by the way? Ultimately, we're talking about something that Islam has recognized from the very beginning. Maslaha, istihsan, in particular. This notion that sometimes you have to not bend the rules, but the rules still apply, but we want to make decisions that are outside the rules or that are beyond the rules, that are fair, equitable. Arbitrators can do that. It's one of the beauties of arbitration, is they can do that more than judges can do that. So give them that express authority in the arbitration provision. It's very important and it's very useful. Okay. That's a thumbnail very quickly on the topic that I was asked to speak about. Let me see where I got with my slides. The future. Let me just say one thing about the future, because the future is important. We need more institutional support for Islamic arbitration. We need more practitioner support for Islamic arbitration. One of the most frustrating things is when I talk to lawyers about Islamic arbitration, they say, yeah, we don't need it. I can just go to SIAC. I can just go to wherever. I don't need Islamic arbitration. But eventually that's not going to work so well, I think. So we need more practitioner support for it. We need more specialized rules for it. We need to create procedures that are unique to Islamic arbitration, I think. This is a tougher sell. This is my own view that I advocate for. We need greater expertise in Islamic dispute resolution generally. This is very important. It's just like construction disputes or labor disputes. We need people that really understand those disputes thoroughly. So it's important. Where are some things happening? I mean, clearly we see Malaysia, KLRCA. We see Basharnas in Indonesia, which is set up to do Islamic arbitration. In Bahrain, BCDR and AAA have worked together. They're trying to develop, they've had some discussions about trying to develop more Islamic arbitration. In Dubai, ICRA as well, set up to do Islamic arbitration. So we're beginning to see the institutional support come in for Islamic arbitration. It's very important. But we need stronger dispute resolution frameworks, and we need more scholars as well. Okay. Thank you. I appreciate your time.